Good morning. This is Sarah Durham, attorney with Blizzard and Zimmerman. I wanted to speak with you briefly this morning about ineffective assistance of counsel. And I know that Jacob has already done a few videos about ineffective assistance. And today I just kind of wanted to, like I said, speak with you briefly about it, maybe tell you something new about it, where it comes from, and how you can explore the case where it comes from. So first of all, ineffective assistance of counsel, like Jacob has told you, has two prongs. You first have to prove that the counsel's performance fell below an objective standard of reasonableness. In other words, you have to prove that the attorney somehow did not do his or her job, like failure to investigate or failure to fully inform the defendant of the result of their plea or something to that effect, right? There has to be something that the lawyer did that fell below an objective standard of reasonableness. So you have that. So that's the first prong that you can meet. And that's not that difficult to meet. Secondly, though, that second prong, you have to show that but for the attorney's ineffective assistance, that the outcome of the trial would have been different. So there would have been a different verdict or a different punishment. And that is where it's a little more difficult to show that prejudice to the client, to the defendant. So those are the two prongs. You've heard Jacob talk about them. You can look at them on, the blog, and so that information is out there. Where did that information come from? Well, the seminal case that set that standard, that set the two prongs, that made that the rule, was Strickland v. Washington, which is a United States Supreme Court case from 1984. And somewhere you can go to look that up free, that and any other case law that you would like to explore, is Google Scholar. If you have not used that, I encourage you to use that. Like I said, it's a free source. It's Google Scholar. I actually wrote it down here in case you wanted to write it down yourself. So Google Scholar, and once you get there, you click on case law, because right now, if you go to the homepage, it's all about COVID-19. And how to find information on that. But so click on the little bubble that says case law, and then it will let you then narrow it down by state and by court. And so you would want to narrow it down to Texas, probably the Court of Criminal Appeals, the Texas Appellate Courts. And then in order to get cases like Strickland v. Washington, you want to also include the federal United States Supreme Court. And so clicking those three things will pretty much give you the body of law that you would want to explore. If you're wanting to pursue an 1107 writ, those are the world you want to explore, is Texas law, Court of Criminal Appeals, Texas Appellate Courts, and then the federal U.S. Supreme Court case law. And that's going to be a ton of information. But if you click on that, you narrow it down, look up Strickland v. Washington, and then within that case, there will be hyperlinks to other cases. And that's kind of how research works, right? You kind of see where these cases come from and what they're related to, and other cases that say the same thing. So that's a really good source for you to use if you want to learn more about the cases and learn more about the topics that you are interested in. You can search by term. So ineffective assistance of counsel or involuntary plea or whatever it may be, to kind of learn more yourself and to teach yourself more about what you can do to pursue an 1107 writ. So I hope that was helpful, and I will talk to you soon. Have a great day.